Late today, a New York appeals court judge denied his motion to delay Monday's hush money criminal trial. And apologies for not prefacing that with "stop me if you've heard this before," because you have. Here's the headline from just 2 days ago. Appeals court denies another Trump attempt to delay trial. Again, that was Monday, seeking more time to pursue a change of venue motion. Ditto yesterday, asking for more time to challenge the gag order their client is under. Today, it got even richer, with one Trump attorney arguing for more time to file more defense motions, to which Stephen Wu, arguing for the Manhattan District Attorney's Office, said was simply not the way these things work. We're going to leave that for our legal panel to sort out in a moment. One thing, though, is clear. These last three motions are only the most recent attempts to delay or derail things. Last week, he filed a motion demanding the trial judge recuse himself for the second time. The first was last summer. He has also tried to exclude testimony from his one-time lawyer and fixer, Michael Cohen. That was denied last month, as was his motion to do the same for Stormy Daniels and Karen McDougal, and motions to exclude virtually every piece of prosecution evidence, including on the catch and kill scheme, which is at the heart of the case. And we should point out, as a criminal defendant, even one who once told police, and I quote, "Please don't be too nice to criminal suspects," the former president has every right to do what he is doing, every right to try to delay justice, even while complaining, as he did yet again today on his social network, that he should have been charged 3 years ago instead of during the campaign. And even, of course, though he's shown up for numerous pretrial hearings in this and other trials, none of which he was required to, and raising money off them all the while. So more on tonight's ruling from CNN's Kara Scannell, who joins us now. So what is the latest argument from the Trump team in this filing?
So today's issue, as you said, there were other issues earlier in the week. Today, the focus was on trying to get the judge to recuse himself from the case. The same arguments we have heard in the lower court argument, where they say that the judge is impartial because his daughter could potentially profit because of work her company does for Democratic campaigns. The other argument was this judge, Judge Merchan, had denied Trump's effort to try to delay the trial until the Supreme Court ruled on presidential immunity in a completely separate case at the federal criminal charges. They're appealing that, and they wanted the judge, the appellate judge, to put the trial on hold for that. I mean, the appellate judge asked a lot of questions here, but Trump's main argument was, they just want another bite at the apple for some of this. The DA is saying, you're not even following the right procedure here. These are things you can't appeal until the case is over. What was interesting is we actually heard from a lawyer for the court today who was speaking on behalf of Judge Merchan to this issue of recusal, saying that there is absolutely no evidence, no proof that he stands to benefit because of his daughter's job. And the judge pretty swiftly denied this.
And there was some special accommodation made today in the court. What happened?
Yeah, I mean, the court's calendar was pretty packed this afternoon. They had oral arguments from other cases that have been pending for a while. So in order to accommodate this, given the nature of the case, the trial starting on Monday, they went into the basement of the courtroom and rearranged tables and chairs to create a bench from the judge, including pulling out a puffy, big kind of procedural chair for the judge, arranging tables so the lawyers had places to argue, and then reporters were sitting on chairs and tables in the back. It was really extraordinary, and what I heard was that it was the first time they've ever done that, but clearly taking all of these appeals very seriously, even though they've all been swiftly denied.
I want to bring in our legal analysts, Karen Agnifilo and Ellie Honig. Ellie, the tempo of this, what do you make of it? I mean, 3 hearings, 3 days, 3 defeats.
This is ridiculous. Let's just say that straight up. I mean, we talked last week, Anderson. I said, next week, meaning this week, expect to see a flurry of motions. But the pace and the nature of these filings, it's outrageous. And look, I have defended and will defend Donald Trump's right, any defendant's right, to aggressively defend himself. But these motions he's bringing, first of all, are completely out of time. He's already brought most of them, as Kara said. They've already been rejected. Now he's just trying again. And there's just nothing to them. And it's interesting, almost borderline comedic, to see how quickly they're being rejected. We're seeing courts of appeals reject these cases in 20 minutes, 45 minutes. So they're trying to give him his say, but there's no appetite here in the judiciary to move this trial.
Karen, I mean, is it done? Because it's only Wednesday, so there's a couple more days.
Yeah, there's 2 more business days. I think we're going to see more activity. This is desperate. The number of times he's been trying to delay this case. The DA's office said it was at least 10 times. Judge Merchan has even put in his orders that the defendant here is trying to delay this case. So the judges and the appellate courts know that this is not just about whatever the motion's about, whether it's presidential immunity or a gag order. It's also an effort to delay the trial and not have it go forward. So they're going to do everything they can to make sure that that does not happen. This case has been scheduled for a long time. As Ellie said, many of these motions have been made already, and many of these things have been decided. And yes, he does have a right to do it, but at a certain point, they become frivolous and they become untimely, and they've already been decided. So he has to watch that. He has to walk a fine line between making too many motions over and over again, the same thing. I think the wild card here is if he goes to the Supreme Court and tries to get them to stop it, because when you think about it, in 10 days, they're hearing the very issue that he wants to appeal, the issue of presidential immunity, and that's being heard on an expedited basis. And so he could go to the Supreme Court and say, look, clearly the judge here is biased against me. I've already made several recusal motions about his daughter. He's gagging me, but he doesn't gag the witnesses. And presidential immunity is an issue that you're hearing in 10 days' time, and he won't even give me 10 days. I think he's going to potentially package it all up and take a shot there and see if he can get an ear or somebody who will listen.
Do you think that has a chance?
I would say legally, no, but in this Supreme Court, it's hard to predict anymore what they may or may not do. I don't think legally there's a basis for it. This is state court. This is not federal, and this is completely separate. Presidential immunity shouldn't apply here because this is all personal. This was his personal attorney. Yes, some of these were done, the checks were written while he was president, but they were personal checks about personal business. This shouldn't have anything to do with presidential immunity. So it shouldn't have any merit or shouldn't have any legs, but that's, I think, his last desperate
Ellie,
thing
with
that
the
he might
process
do.
of filing that with the Supreme Court or going to the Supreme Court, would that automatically delay jury selection on Monday?
No, only if the Supreme Court were to step in and say, hey, put a hold on this. I agree with Kara. I think if there's one more shot, that would be it. I also agree that it will lose on the substance. There's a legal doctrine called abstention, meaning the federal courts, including the U.S. Supreme Court, are very reluctant to step in and pause things at a trial level at a state court. And I have to say this, when you're a lawyer, your credibility is everything. And you get to a point where you start to lose it with the judge. It's like a boy who cried wolf phenomenon, right? If you come in every day, 2-3 times a day and say, oh my gosh, we have this emergency. Oh my gosh, this is such an urgent situation. You have to pause it. The judge is going to start tuning you out. And I think Trump's team needs to consider that.
The former president today shared this social media post in defense of himself from Stormy Daniels' former attorney, Michael Avenatti, who is in prison right now. And Trump added his own commentary, calling Daniels and former Trump fixer Michael Cohen, quote, sleazebags. They're both likely witnesses at the trial. Would that violate the gag order?
100%, yes. And up till now, Trump had been sort of crafty. What he was doing was taking other people saying things that would have violated the gag order and just retweeting or retruthing that, which was maybe a gray area. But now he says, he calls the two main witnesses sleazebags. And this is a moment of truth for the DA. The DA needs to go to the judge first thing tomorrow morning and say, this violates the gag order. You need to do something. If you don't enforce discipline right now, it's going to get away from you.
Do you agree with that, Karen?
Yes, and at the same time, it's clear that Trump is trying to bait the judge. He wants more evidence to go to the Supreme Court to say he's biased against me, and the judge is not going to take the bait. So the judge is going to do everything he can to make this case go, and so I think those questions and decisions are probably happening right now in the DA's office.